My name is Ahmed and my roll number is LH18016. My topic of presentation is Minor Offences Code. Its introduction is this law is enacted related to small claims and minor offences and for providing inexpensive and expeditious disposal of such claims and offences. Short title, extent and commencement. This ordinance may be called as Small Claims and Minor Offences Code Ordinance 2002. It extends to whole Pakistan. It shall came into force on such date as federal government notified in official gazette. Its definition include different things. Amicable settlement includes settlement through arbitration process other than arbitration under the Arbitration Act 1940. Wards mean finding of a salis. Court means the small claims and minor offence court established under section 4. Salis means the person acting as conciliator, mediator or arbitrator. Establishment of courts. The government in consultation with High Court may establish one or more small claims and minor offences court in each district or at such other places as it may deem necessary. The court shall be presided over by a civil judge or judicial magistrate. The jurisdiction and limits of such court shall be defined by High Court. Now we discuss the jurisdiction of these courts. The court shall have jurisdiction to try all suits and claims arising therefrom specified in Part 1 Schedule to Ordinance. Its jurisdiction shall not exceed limit of 100,000 rupees. It shall also try offences specified in Part 2 of Schedule. And the procedure in civil trials. Every suit before the court shall be instituted by presentation of plaint duly verified on oath. The plaint shall contain all material facts relating to claim or dispute. The plaint shall be accompanied by as many copies including schedule and list of documents referred to in clause 4 as there are defendants in suit. The plaint shall be accompanied by one-time process fee of 25 rupees. Rejection of plaint. The plaint shall be rejected in following cases: where it does not disclose a cause of action, where the relief claimed is undervalued and plaintiff won being required by the court to correct the valuation within a time to be fixed by the court and fails to do so, where the relief claimed is properly valued but plaint written upon paper insufficiently stamped. Now summons. The court shall within 2 days of presentation of plaint send summons to defendant for final determination of suit through process server and by registered post. Where in any case if defendant not found and nobody available to accept summons on his behalf, service may be made on any adult member of family. When court feels that defendant is not cooperating in accepting summons, the court shall order for service of summons by affixing copy of summons at conspicuous part of house, publication in press or any other manner as it may deem fit. Appearance through advocate for parties. No advocate shall act for any person in court unless he has been appointed for purpose by such person in writing, signed by such person or by his recognized agent. The provisions for the service of process on a party to suit shall apply to service of process on his recognized agent. Any process served on recognized agent of party shall be as effectual as if the same has been served on the party in person. Appearance of parties and effect of non-appearance. Where on the day fixed for defendant to file written statement, it is found that summons have been served but defendant failed to file written statement without sufficient cause, the court may proceed ex parte and pass decree. यानी कि अगर डिफेंडेंट ना ही के रिटर्न स्टेटमेंट जमा कराता है ना ही खुद पेश होता है तो कोर्ट यकतरफा फैसला कर सकती है. If court finds that defendant have sufficient cause for not filing statement, it may set aside decree subject to such terms as to cost payment into court or otherwise as it deem fit. Whether neither party appears when suit is called for hearing, the court may dismiss the suit. Amicable settlement. In proceeding, if it appears that amicable settlement is possible, The court may appoint salis for mediator or arbitrator purposes on consent of parties, provided that the court shall not proceed for amicable settlement of offences which are non-compoundable. यानी कि जो केसेस मसालत से हल नहीं हो सकते वो कोर्ट की जुरिस्डिक्शन में नहीं होते. If a settlement is reached between parties to claim a settlement, statement of compromise shall be prepared and court shall pass decree accordingly. Settlement of suit and awards. If settlement of suit is reached between parties, the salis shall prepare a deed of settlement containing terms of such settlement signed by the parties and submit it to the court on the day fixed by court, with a certificate that the settlement between parties was voluntarily. The salis shall make an award and submit it in the court on or before the date fixed. The court shall, before passing order based on award, call objections of parties to it within 15 days of receipt of award and settle such objection within 15 days. Failure of settlement. If no settlement is reached between the parties, the salis shall record the statement of the fact signed by parties and submit it to the court on or before the date fixed. Prohibition of making record. Any information, statement, document, and anything disclosed to the salis during settlement proceeding shall be kept as confidential, and no document including any transcript, formal record, or audio-visual recording shall be made of proceedings except with the approval of salis and consent of parties. Evidence. In civil matters, production of witnesses shall be the responsibility of parties except official witnesses whose appearance shall be determined by court. On application of parties, the court summons witness. The evidence of witnesses in attendance shall be taken orally in open court by the judge. Power to order any point to be proved by affidavit. The court may at any time for sufficient reason order that any particular fact may be proved by affidavit, or that affidavit of any witnesses may be read at hearing on such condition as the court think reasonable. Power to order attendance of deponent for cross-examination. Upon an application, evidence may be given by affidavit, but the court may, at instance of either party, order the attendance for cross-examination of deponent. Such attendance shall be in court unless the deponent is exempted from personal appearance in court. Examination of witness. The court may at any stage of proceeding and under exceptional circumstances call a witness for examination or re-examine a witness already examined, if so required for the ends of justice. The court may refuse to summon a witness or enforce the summons already issued against witness when in no option of court the attendance of witness cannot be procured without such delay, expenses, or inconvenience as in the circumstances would be unreasonable, or such application is moved in bad faith to protract the proceeding or to fill up any lacuna in case of either party. Conclusion of trial. The court shall conclude the trial within 60 days by taking day-to-day hearing, unless prevented by good cause, in which case the case shall be disposed of within the next 30 days. On completion of evidence, the court shall fix a date not exceeding 7 days for hearing of arguments of parties. When the case has been heard, the court shall pronounce judgment in open court within 3 days. The court shall also provide copies of judgment to parties. While pronouncing judgment, the court comes to point that claims or defense is false, it may order for payment of cost. Execution of decree. A decree passed by the court shall be executed by court for by another court upon transfer for reasons to be recorded by the court passing the decree, and transfer court shall execute it as if the court decree was passed by itself. Objection against the execution of decree shall be determined by court. The court shall continue the execution proceeding except when stayed by appellate court. The cost in execution of decree shall be determined and paid as directed by the court. Inherent power of court. Nothing in this ordinance shall be deemed to limit or otherwise affect the inherent powers of court to make such order as may be necessary for the ends of justice, or to prevent abuse of the process of court in respect of resolving disputes mentioned in Part 1 of Schedule. Power of court. Subject to this ordinance, the court shall for purpose of any case under this ordinance have powers of civil court under Code of Civil Procedure 1908, summoning and enforcing the attendance of any person and examining him on oath, local inspection, and issuing commission for examination of witnesses' documents. Appeal in suits. An appeal shall lie to court of district judge within 30 days of passing of decree of final order by court. No appeal shall lie against the decree of court based on award except on the following grounds: the salis has misconduct himself or proceedings, that an award has been made after issue of an order by the court suspending the salis or after proceedings of award have become invalid by the court, that a decree based on award has been illegally procured, and no appeal lie against the decree passed by court with consent of parties and under this ordinance. Appeal in criminal proceedings. Appeal in criminal proceedings shall lie to Court of Sessions within 30 days of conviction. Amendment in Schedule. The High Court may amend the schedule from time to time in interest of justice. The High Court may also make rules regulating the procedure of court. Schedule Part 1. It includes matters of suit for recovery of money due on contract in writing, claim for damages on account of contract in writing, suit for specific performance and for recovery of movable property, suit for compensation, redemption of mortgage property and for enforcement of easement rights, suit for damages by cattle trespass and compensation for traffic accidents. And Part 2 of the schedule include all offences in Pakistan Penal Code punishable with imprisonment not exceeding 3 years or with fine or with both. Part 2 of the schedule डील ऐसे केस से डील करता है जो पाकिस्तान पीनल कोड में दर्ज हों और जिनकी सज़ा 3 साल से ज़ायद ना हो. And this was the presentation of small claims and minor offences codes.